Yet again, a Colorado court has allowed another assault on the religious liberty of baker Jack Phillips to continue. This time, Jack Phillips of Masterpiece Cake Shop is being forced to bake a cake celebrating transgenderism, something that he says defies his religious liberty. When this case inevitably makes it to the Supreme Court, it's time once and for all for John Roberts to let the court take the question underlying all of these religious liberty cases seriously. The initial Supreme Court case, which found in favor of Phillips, was celebrated by conservatives, albeit prematurely. Phillips, who first went to the Supreme Court after Colorado demanded that he must bake a cake for a gay wedding, was found by the court to not have to do so. But it wasn't because the court decided that his right to free exercise triumphed over all other anti-discrimination statutes. Instead, the Supreme Court ruled that Colorado had demonstrated bias and aggression against Phillips in deciding the case. That is, that if they hadn't been biased against him, they still could have forced Phillips to bake the cake. A similar level of premature celebration was found when the court, in a 9-0 ruling, found that Fulton County could not discriminate against a Catholic adoption agency, which refused to certify same-sex couples as prospective foster care parents. But again, in this ruling, it wasn't about the broad idea that free exercise takes precedence over other anti-discrimination statutes. Instead, they simply argued that the rule itself was not neutral. Sure, this meant that Roberts, who loathes to appear partisan, got his 9-0 consensus, but it meant that, once again, the actual status of religious rights remain in limbo. It's time for the court to decide once and for all whether or not the free exercise clause of the First Amendment reigns supreme. And indeed, we all know, based on common sense, that it does. Your right to worship triumphs any anti-discrimination act that came after it. This is true regardless of the law's intent, regardless of if it's applied or written with an intentionally biased way, or no matter what the outcome is. The First Amendment is first for a reason, and it's time for the Supreme Court to explicitly say so.